Welcome to the WorkHARDAholic Show with your host, the original WorkHARDAholic, Shirley Crawford, author, speaker, and small business consultant for over 20 years, helping you to work hard, play harder, and business better. Hello, 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 and welcome back to WorkHARDaholics. Oh, okay. So this is our first episode on the radio. I feel very excited.
You should.
Okay. All
Emotional.
Right. Thank you. This is a big deal. So the show, once upon a time, years ago, used to be on the radio. We switched to live podcast. And so now we are returning back to the box. We're returning back to the radio and very excited about that. And so because we're coming back, that means I have to share with you all our theme song, which I had stopped singing a long time ago. But now that we're back and you all don't know it, I have to share it with you. Author Shirley Crawford. Y'all ready? You ready? You ready? You ready? You ready? For those of you who are wondering what does it mean, it's the movers and the shakers always doing something. If you want to be in balance and get some more green, work hardaholics, and the crowd goes wild. You can tell it's been a while since we've sung that little ditty, but yes, this is WorkHARDaholics, where we learn to work hard, play harder, and business better. I am Shirley Crawford, your host, the original WorkHARDaholic. We changed keys there. But yeah, that's me. Also the executive director of the Women's Business Center, RVA, located at 1510 Willow Drive, directly across the street from the Kroger at Willow. So, and I've been a small business consultant for over 25 years. Yes, the gray hair is legitimate and real and earned. And to kick off this new show that we are so excited to have this July 10th of 2022, we are so excited that we started off with a bang, and we have with us today none other than Caroline Fox. You said Caroline or Caroline?
You know, I say Caroline, but I'll answer to almost anything. You know, my mom was one of those that would just cycle through everyone in the family, like the dogs, the cats, before getting your name right.
Do you have a few siblings?
No, I only have one sibling.
Oh, wow.
We don't know. I don't know.
Wow. See, I'm one of 6. So
there's an excuse there.
I'm used to the being called everybody's name, including the pet.
Yeah.
Yeah. And she's always like, you know who I mean? Actually, I do.
It's like, I do know.
I do know who you
I'm choosing to ignore you, but yes.
Well, we're going to make sure we have it right because you are someone to truly be respected. Caroline.
Thank you.
Caroline Fox.
Thank you.
All right. And so I'm going to make sure I'm going to try to say it correctly. But if I don't, she will correct me because you must always correct me. Caroline is a patent and trademark attorney as well as I said patent. I didn't mean to.
It's okay.
I didn't mean to. She's told me several times, not patents. That's for someone else.
You're good.
Copyright and trademark
yeah.
attorney as well as a corporate attorney.
That is, you got it. Spot on.
Okay. And so she's also part of a group that I belong to called Boss Babes. Hello there, Boss Babes. If you're not a part, well then, sorry. So please tell us a little bit more about you.
Yeah. So I am, a lawyer. I work with a lot of small to medium-sized businesses, usually pretty brand-heavy businesses. I started in PR and advertising, and I was like, I really like the legal side of this, and I was not ready to be done with college and school, and so I was like, I'll just go to law school.
Some people enjoy that.
Yeah, so law school is rough. It is intense, but we made it through. I did a little bit of time after law school up in New York, trying to get a feel for it, see if I liked it enough to stay there long term. I decided it wasn't for me, but I'm so glad that I spent time up there. So I was up there working for Sony Music. So it's like there were interns, and then I was below an intern.
I'm sorry. Only Caroline could just casually drop the fact that she worked for Sony Music. For those of you who didn't hear it, we heard it. Okay. Yeah, please continue.
Well, I mean, like I said, I was the lowest of the low on the totem pole. I was running, doing errands sometimes, and the interns at least had a structured program, and then there was me who was just kind of out on my own, just
you were the jack of all trades.
Exactly. They're you should know what you're doing because you graduated, but you don't, so we're just gonna throw you a bone. But yeah, so I decided, well, it wasn't, I'm from the middle of nowhere, very rural, so originally. So I came back to Richmond because this had
But where are you from originally?
originally from the Eastern Shore of Maryland, but it's
Oh, okay.
it's the part connected to Delaware that most people think it's Delaware. There's like island people, like there's like my family's. We didn't even really get internet at our house until like 2011, 2010. We were like on the old copper wiring, so it's
Oh, wow. But it's out there,
it's out
though.
there.
When I was in high school, I went to a weird, lovely Richmond Community High School. Shout out to you. So yeah, little weirdo school.
Yeah.
School for the gifted and talented. Let me stop diminishing my lovely, amazing alma mater. Love you. And so we actually stayed on one of the islands in the Eastern Shore.
Tangier.
It's underwater now.
Oh, okay, yeah. So that's almost underwater, but not quite. Yeah.
So I know exactly the area.
Yeah.
And it took quite a journey to get there.
Yeah.
And then we had to take a boat over, and it was quite the experience. I shall never forget. So actually, the Eastern Shore has a very special place in my heart
Yeah.
that I'm not returning to.
Yeah. It's weird. And I'm from the movie Wedding Crash was actually filmed in my hometown, which is hysterical to me. Like, it's so funny. I know people in it, and but so it's beautiful and it's a wonderful place to grow up, but it's definitely like isolated, which could be good or bad.
That's my first place I ever experienced a ghost crab. So
Oh my God, yes.
That's what I know. Yeah, and Smartina Alterna Floor. I'm trying to tell you, it was an amazing experience. So but you were saying you came to Richmond.
Yes. So I came back to Richmond. I went to law school here, and so my base was here for a support system because I knew exactly what I wanted to do. And with legal kind of hiring, it goes everybody's outside law firms, everybody's in-house at companies, everybody's outside, in just like a structured law firm. Then they hire everybody and they go in-house. So it kind of goes in waves. And after the 2008 crash, law, it took a little bit longer to hit legal, and then it took a little bit longer for legal to recover just because it's kind of, I graduated in 2013. And so it was still kind of like, what's going on? And there were a lot of people still vying for jobs. And I knew exactly what I wanted to do, like for the first time in my life. I knew exactly what I wanted to do and who I wanted to work with.
It's a great feeling.
Yeah, it was great. And I was like, I want to work with like advertising agencies and companies like that, like creative digital agencies. And I was like, I don't want to work at a firm. Like, I don't want to work at a law firm. And when I was going through U of R, they didn't have resources for that at all. They were just kind of like, oh, you don't want to work downtown at a big law firm. Like, we're not really sure what to do with you. So maybe go talk to the IP people. So that's where I got into trademarks and copyrights, because there's a lot of that in advertising as well.
IP as an intellectual property.
Yes, ma'am. I should have said that.
We're used to alphabet soup around here. We always talk about it.
Yeah.
SCC, SEC, LCC, LLC.
Yep.
Yeah. It's all just alphabet soup.
Yeah, the SCC and the SEC, they're the ones that'll get you really. If you confuse them, they'll get mad.
There will be jail time.
There will be jail
if
time.
you get too confused.
Exactly. So I did that. I was young and dumb and naive and didn't have any assets to so I just started my own law practice. Because when you're and I was 25. I was 25. And when you don't have anything, there's nothing to lose. So I was like,
this is true.
There's
not too much to risk.
Right. There was no risk.
And you had time enough to recover.
I had time to recover, and I was like, look, I'm going to figure it out. And so I made a PowerPoint presentation and charts for my parents and why that they should support me.
Be your first investor?
Yeah, essentially support me and think that it's a good idea, because you want your parents' approval. And as a firstborn Virgo child, yeah, I needed that. So I started it, and then 2015 to it was 2014 to 2015. I don't know. I practiced for a full year. There was another law firm that was based out of Roanoke or Blacksburg, sorry, that they wanted to open an office here. One of my girlfriends from law school worked there. They kind of acquired my practice, but also I went to work. So I went to work for them, and we opened the office here.
That happens a lot.
It does. A lot. It was a good year. It was a good experience in so many ways, but in many, many ways, it was one of the worst experiences of my life. Eventually by the end, all the lawyers had left that law firm. It was just very toxic. So I was one of the last people to leave, but because I was like, oh, man, I've only been here, a year and a half, 2 years. I don't want my resume to look bad.
But when that happened,
Mm-hmm.
did they acquire your book of business?
No, because lawyers can't sign non-competes because we wrote it into the law somehow because we're sneaky AF. And so I was just like, all right, I'm out. I'm leaving. And he was not great about it. I had to get my own lawyer.
Wow.
Jack Birch, a pillar of this community. Thank the Lord for him.
Wow.
Yeah, so it was a good experience in that I got to understand what it feels like to be a client when you're waiting on your lawyer to call you back when you're panicking, and it's like your lawyer knows that it's probably not a really big deal or that like it's going to be okay. But like as a client, you're having an emotional spiral breakdown.
Yeah, it's like the doctor-patient situation.
Oh, yeah.
You never know until you're the one that's having to have the services done.
Yeah.
You're like, this is important.
Right.
But when you're on the other side, it's like, it's no big deal.
It's like, oh my gosh, this is like the least of the problems on my desk today. Like I promise you're going to be okay. Yeah, but when you're in there spiraling in your brain, yeah. So that was hard, but that was back in 2017. And then after that, I was like, no, I'm doing this. I'm doing what I want to do now. Like, I'm not doing that again. So I had offers to work at firms downtown. I had a couple other offers, like big firms, mid-sized firms. And I was just like, I don't want to deal with all of you. I'm done. So now
Enough of being an employee. For
Yeah.
those of you who are employees, okay. All right. But for the rest of us,
there are perks.
There are.
There are so many perks.
I miss I used to tell people I worked for GE for a while.
Ugh.
And oh my goodness, because you make so much.
Right.
And then because, they always teach you to be diligent about your funds, like I had money that automatically went to stuff and I never noticed it.
Right.
And so then later on after I'd left, I was getting random checks in the mail.
Yeah.
Like things were maturing. And it was just like, I would see these checks and I'm like, oh my God, I remember.
Yeah.
I remember when
401ks.
I remember that.
Right.
But even after all that, I can't go back now to save my
Oh
life.
yeah, I'm ruined.
I really tried. Like I've gotten phone calls like, do you want to come back? And they're like, oh, that's great. No, I can't.
Yeah.
It's hard to be an employee after you have been like your own boss.
Well, yeah, absolutely. I say that now, like I'm ruined. I could probably never go back working for somebody because I have like very intense thoughts about efficiency and like things that I want a certain way. And
you can do it whatever you
Yeah.
you are Burger King, the Burger Queen. You can have it your way.
yeah.
So now you're married.
Now I'm married and I'm pregnant,
got
20
a baby
weeks.
on the way. So when we talk about workahardaholics,
Mm-hmm.
we're always talking about the balance,
Right.
right? To be able to live in balance. But we're talking lawyer,
Yeah.
where billable hours and all kinds of things that you have to account for. And are you in court at all, or is everything for you administrative?
I mostly do like transactional work where it's like company, like one's buying another one. There's a trademark issue. Like we'll have disputes and negotiations or things like that. But first of all, most cases aren't going to go to court anyway. I think it's like 90% settled before trial, and then like the other 10% like almost settle or whatever.
I have to point out this random fact. So I had a court case, and so I was adamant about the principle.
Yeah.
So I wanted to go to court for it.
Mm-hmm.
And so I went the entire time of the other party trying to offer me all kinds of stuff to not do it. And then, like, I think literally, like, 2 days before, my lawyer was like, can we please settle this case? And I'm like, it's the principle.
Yeah.
And they were like, we don't go to court. Not really. It's like, I'm paying you.
And you're like, why did I just pay you all this money?
Why did I wait 2 years? 'Cause
Yeah.
that's a lot of time going back and forth. And they're like, we don't really go to court.
Oh, God.
We don't really go to court. I mean, we can if you really, really want
Yeah.
to. But you're not going to get anything better than this deal.
Right. Yeah. And that's the hard part.
Sucks.
And, I will go to court, and I do. So trademark court, it's at the TTAB, Trademark Trial and Appeals Court. It's in Alexandria. It's essentially court without standing up in front of people. You just write a lot of papers back and forth, and like judges make decisions. So it's great. It's very administrative. The Copyright Board just released, it just started last month, and it's going to be very similar.
Mm-hmm.
So I do that. I mean, that's totally fine. I'll take like one case a year that's like court bound that I know we're going to have to go.
To keep your skills sharp.
To keep my skills sharp and to just ensure that I know what's going on. And I do serve as essentially like an IP expert counsel for litigators. So litigators are people that go to court all day, every day, love it, like to argue, all that kind of stuff. So a lot of times
You're that subject matter expert.
Yeah, I just am essentially a subject matter expert. They'll bring me in, they'll be like, hey, make a plan, help us figure this out. What are we arguing? and then, I'll give the reins back to them and let them do their magic, because it's, especially with smaller firms, you don't always have your subject matter experts, or you don't always have.
Yeah, it's expensive.
It is. It's very expensive. So I work with a couple. Well, one of my colleagues is wonderful. He's an IP lawyer as well, and he was with me at that other firm where we all end up leaving. And we work together a lot. So when there's ever any sort of court case litigation type thing, we work together. But yeah, it's been really cool working with other lawyers, because you get to see what they do and like how they handle things. And now that my companies have been maturing, I'm essentially they keep me in the loop, even though I'm not maybe necessarily arguing in the state of California for whatever they're doing here, because they're like, we trust you. We know that you are listening, and like, we don't know these people. So can you be the go-between? And that's been really cool, because it's like, wow, they trust me enough to pay another lawyer to look over this, somebody else's stuff and translate for them.
But let me ask you something, because that comes to a very interesting point. Something in particular I know about trademarks and copyright, right? Because we have local, like you can file for Virginia.
Yes.
But then there's federal.
Yeah, so for trademarks, there's local trademarks, which is, they're state trademarks, and they're more of like your common law type trademarks. And then you have your federal trademarks, with the federal trademark rights that are granted essentially through the Constitution. Well, through the Commerce Clause of the Constitution is how they're all regulated. If you think back to like 8th grade civics, like
8th grade was a long time ago. It was a long time ago.
Yeah, well, I mean, some people remember like, oh, the Commerce Clause, that's how everything happens. Like, basically, that's the government's way of.
I remember how a bill is made.
There you go, a bill on Capitol Hill.
Yeah,
Schoolhouse Rock.
I know the
exactly.
Schoolhouse Rock.
Yes.
Good job, people. Still using you.
Yes. Oh my God,
That's
love them.
That's also why I know the preamble to the Constitution.
I knew it at one point. I don't anymore. I'm not gonna.
I can still sing it. I won't. But I
mean,
know.
you can. You could. So yeah, your state trademarks, I rarely file those, because I don't find that, especially in a digital age, I don't find they're super helpful unless it is a strictly local brick and mortar company that I know is not going to franchise. They're not going to expand out of state. They just want to protect what they have here, lock it down. And then, so usually we go the federal route, because like I said, and everybody knows everything's digital. You could be a company and you're like shipping out to different states. You could be, if you're a consultant, then you have clients in different states. You're on the internet. You don't want to get into that.
But the pricing is like significantly different.
It's much, much different. I will say that, yes. So, and I'll just talk filing fees. Filing fees at the USPTO went up actually in December.
The United States Patent and Trademark Office.
Yes, United States Patent and Trademark Office, sometimes referred to as the PTO, sometimes just the USPTO together. So for a federal trademark application, it's $250 in application fees per class of goods and services. And what that means, there's 45 classes of goods and services, which is just some like a bucket of stuff that the USPTO examiners think are related. And we're in Virginia, so this is my analogy too. And I also say they're less like a basket and more like a crab pot, like underwater, because stuff can kind of, I know it's so bad.
I wasn't expecting that, Caroline. I wasn't expecting that.
I love visuals.
Okay.
I love visuals. So because too, like you register in certain classes, and sometimes they're a little bit like wishy-washy, where it's like, oh, you're in class 35, but it's kind of like class 42. So stuff's going to go in and out of the same ones, and like, oh, maybe they're too related. And that's when we're getting into like confusion issues. But
okay,
your classes of goods and services, they're kind of like a crab pot.
Okay. So part of the reason why I was so excited to bring you on is because I always love, like everyone knows, I love it when real life intersects with business.
Yes.
Because oftentimes when I'm talking about, consulting or other aspects of business and all of our alphabet soup, people's eyes glaze over.
Yeah, and it's so cerebral and up here, and it's like, I don't care.
But I'm like, it's every day.
Yeah.
And here's a moment to know this is every day.
It
so
is.
I was sharing with Caroline, for those of you who are DD4L fans, for those of you who watch Bring It, if not, go watch it. It's on YouTube. You can go watch it. I think it's still on TV. They just had like their
I think it is on TV.
I think they have been around for a while. I think it was like their 40th anniversary recently. It's something crazy. It's like, I was like, maybe it's 20. Either way, they just had some major anniversary.
Yeah.
Had this whole tour. So for those of you who don't watch, okay, let me update you very quickly because we want to get to the point. So, and we'll share part of the clip so you all can see it.
Oh, perfect.
So the deal is that Miss D, who is the coach, the university, I'm going to forget the name.
Southern Methodist. I looked it up.
Is it Southern Methodist?
Mhm.
I will say Southern. See, Caroline is on her stuff. That's why she's the attorney. I'm just the consultant.
Oh my God, stop.
So Southern Methodist University issued Miss D, Coach Diana, something Williams, Washington, whatever her last name is.
Don't know that one, but
She got a trademark for it, so I should try to remember it. But they gave her a cease and desist to stop using the name Dancing Dolls. So for any of you all who are remotely familiar with this dance team, they had the show on Lifetime. They have tours that come everywhere, including Richmond, Virginia. They do the competitions. Like, they're out there doing it. Everybody knows who Dancing Dolls is because of them. But they got the cease and desist from Southern Methodist. Thank you, Caroline. But apparently, so Miss Diana made this. She went on one of her rants. If you've seen her, you know she's very assertive. So she went on this rant on her Instagram or one of her social media channels, and she shows the cease and desist letter, and then she proceeds to talk about the situation. So the cease and desist said that they couldn't use the name Dancing Dolls anymore. Southern Methodist has their dance team, and they're called the Fabulous Dancing Dolls. So that's what everyone knows them for. But her statement was, why go after them? There are Dancing Dolls teams all across America. And it turns out there are. There's even one down the street from the university. So she's like, why go after us? So clearly you all want to be petty. So she said, I'm going to be petty too. So she filed, I would say, counter trademark copywriting things with the USPTO, which means she had money to spare because, oh my gosh, she went for several classes. And so I'm going to say wrong, but Caroline's going to correct me because she's going to talk to us about like what all this means in real life as a small business owner. Because I'm sure you've thought about it. Like, do I need to trademark my name? Do I need to know about a service mark, a registered trademark, a copyright? There's so many different marks and things that you all can go for, but a lot of small business owners have no clue. So this is a great time to like learn the difference. So Miss Diana went for, I think, Dancing Dolls in one category. So they are not allowed to use Dancing Dolls on like merchandise for events and competitions and some other things. Like, she went after a bunch of different categories. And then it turns out that they never trademarked their own name. So they went for Dancing Dolls, but not for Fabulous. And so she trademarked, let's be clear, she applied for, that's a process involved in that.
It's a process.
And so she applied for Fabulous Dancing Dolls. I know it's in merchandise because she's like, you can no longer have your name on your own stuff anymore. So, and interestingly enough, after this all happened, Fabulous Dancing Dolls, who apparently before that never sold merchandise with their name on it because they felt like you had to be a part of their group to do it. They are currently, for the first time ever, selling merchandise with their name on it, I guess, until there's a cease and desist and they can't do it anymore, or if it's been approved. So now Caroline's going to clarify for us, like, what does all this mean? Because she went after various categories. And so, especially when you're talking about the fact that you have to, you pay your fee to file, and then you pay for each category as well.
So you pay that fee for each category. So your filing fees are based on number of categories. So yeah, it's $250 per class. And I'm like, when you've been talking through this, I've been kind of just looking at their classes. Yeah, so basically what this means is that the bottom line is it's just going to be very expensive for both of them. At the end of the day, I mean, really, that's what it is. And I think that I could talk for a really long time about this, so I'm just going to try and like shrink it down because there are so many different moving pieces here. Trademark law is one of those areas of law where it seems very straightforward, and when things all go well and correctly, it is pretty straightforward. Like, you could just file an application and get the application through and be good. But when things don't go well, which happens a lot, it is very confusing, and you've got one of these situations. So there are a couple of things that I see. There's some common law trademark issues here where you have rights just from using the name first in time. But those rights are boxed in, and this is another visual. So like common law trademark rights are if you envision a big mouth mason jar, the biggest one you can think of, and you drop a ping pong ball in. That's kind of what rights automatically pop up from you just using a name in commercial activity, right? That's a common law use. And so you can develop those. But what federal trademark rights do is they act like sand. So if I just poured sand on top of everything and filled up the rest of the jar, that federal trademark right would encompass the rest of that mason jar, and they would have rights everywhere that ping pong ball wasn't. So the issue here is there's Lifetime, which is across the country. There's a university, which has huge ties across the country. You've got local common law trademark issues where both parties have used it in a certain way. Both parties have used it commercially. Which one has used it when? Who was first? Who was last? That's a problem. And then you also have this counter argument that neither party should get it because they have not policed their rights. And policing your rights is basically you have to stop people from using your trademark if you see them using it
and let me
without you.
Just comment there for a minute, because if you all have heard me talk about like trademarks and copyrights before, we talk about there is a local shop, a bar. There's a local bar in Virginia. And so Starbucks sued them over using, I don't know if they use Frappuccino. They use something that everyone understood to be a Starbucks thing. And so even though it's alcohol and Starbucks is coffee, because they have to police it, they have to show they're trying to protect their name. And even though it's a little mom and pop shop in Virginia, and fortunately for them, it brought them more publicity and they're very excited about it. And so they were fine with renaming it something else. They have to do it. Because I also go back to, I know this, the two stories I always tell, I talk about that one because that wasn't too long ago. But then Xerox. And so the case with Xerox was they allowed everyone to use it. So Xerox became generic, an adjective as opposed to a name. So then when they finally filed, they lost.
It's death by genericide, essentially. There's Velcro, actually, if you want to watch a funny video, all their lawyers did a very funny, please don't say Velcro. It's called a Hook in a Loop. It's like a music video that they made with all their corporate lawyers. Very funny.
To check that
out. Yes, please do, because it gives me the biggest giggle. But yeah, like you said, a lot of times when you get a cease and desist from a trademark owner, a lot of times they're not even being like as proactive as they should be. They're just like, oh, we can't let this happen anymore. We have to go after these. Like, we have to tell them. I work with plenty of businesses that they don't want to go after small companies, big companies, everybody in between, but they have to, because in order to keep your rights, you make a deal with the government that you're going to protect consumers by using that name in a certain way. And that's where the rights all stem from. I tell people trademarks are not about you. They're not about your company. It's not like you get this trademark. It's you get the right to protect consumers by using this mark in a certain way. So framing it that way kind of helps people understand that that's why a lot of cease and desist marks end up going out. And you see larger companies, especially the beer and spirits industry, doing a really good job at sending letters that are like, hey, so we don't want to have to be sending this, but here's the issue. And like kind of explaining it and being funny about it and being like, we're going to give you 30 days to rename. Here's a swag box, like no bad blood. Sorry, we just have to, this is part of our responsibility. So you're seeing a little bit more of that now, and I work with brands who are a little bit more flexible like that, and they really want those kinds of interactions. But yeah, it's definitely a problem because, like you said, there's dancing dolls all over. So you really can't say that they've got rights in that mark, that they've protected rights in that mark. I mean, especially because these are both filed fairly recently. You've got decades of not enforcing it. So I think that that's going to be a very strong counter argument. I mean, for both of them, truly, they're going to be shooting themselves in the foot by making those arguments at times, because they're going to be saying, oh, well, I mean, I can only imagine what they're going to be filing just generally. It's going to be a long, protracted, expensive battle. But the reason at the root of all this, it's you file as soon as you can, and you want to make sure that you protect your rights. Because if not, you could end up like this. Or you could end up like some of my clients where I have to give them a phone call and say, hey, I know that we were planning on filing this application, but I went through the USPTO, I pulled a report back, and there are names that are way too similar to yours, and I don't think you're going to get this. I don't think it's going to go through. And so we're left with, okay, do we oppose this other person's trademark and try to get it canceled, which not always possible? Do we essentially go back to square one and rebrand?
Or wait for it to expire?
Do you wait for it to expire, which can either be 5 years, 10 years, what you're waiting on there. It's a very difficult decision for people to make because people get very, very emotionally attached to their brands, which when you're making emotional decisions, you're not making good business decisions.
Indeed.
Business is emotional, like it is, especially small businesses, but you have to be able to take yourself out of it for a minute. And that's where it gets really difficult. And those are the worst conversations to have, at least for me.
Can you tell us about the categories, especially in this situation?
Sure. So from what I can see, at least in this situation, you've got, so it looks like they've registered in like the merchandise, some merch, some looks for like clothes and apparel, but it also looks like they've done services for entertainment and dancing. One of them is in one of them's in the other. It looks like they've kind of switched them. What I'm interested in seeing is, since the dancing dolls lady, she doesn't use Fabulous Dancing Dolls. You can't just file that without use. So she's going to either have to start using that, or like she's not going to be able to claim it. I mean, I guess she filed it as an intent to use application and will be starting to use that, but I don't know. I mean, she's putting herself in a very interesting position because also dancing dolls and Fabulous Dancing Dolls, they're not going to be considered different enough at the USPTO to get through, because trademarks are not like screen names. They're not like social handles where you can put, oh, well, my social handle is not available that I want my name all the way through, so I'll just put a period in between the words, or I'll add an S. It's a holistic evaluation in sight, sound, and meaning. So what it looks like on paper, what it sounds like when you say it, and what it means when it's written out. Or if it's like a translation from another country, like gato and cat would be the same thing in the eyes of USPTO. So the example,
Really?
yeah. So the example I give a lot of people, I say, which I love this, another like Eastern Shore analogy. Have you ever seen the competitions where the dogs just like run as fast as they can, jump off docks, and they like measure how far they jump?
I have not.
Okay, it's like
sorry, visual in my head.
Yes,
okay.
It's very funny, and like you get these like German Shepherds and Malinois who will jump like 16 feet, and then like somebody will enter a bulldog and they'll just like fall off the ledge. But my example that I give is Doc Dogs for that kind of competition, DOCK space DOGS, as you would just spell it normally. At the USPTO level, it would be considered the exact same for that type of activity. Maybe somebody else wanted to host a competition as DOCKDAWGZ or
okay.
S or whatever. We consider it exactly the same. Now, if one of those was for, the actual dog competition, and then one of them was for, I don't know, life vests, that could potentially be considered as something different. And so then one of them they would both possibly be able to get through.
So the intent actually does matter.
It really does matter, like the intent and what you're actually using it on. And you can have it in, there's Dove chocolate and Dove soap. If Dove soap came out with a line, or if Dove soap came out with a line of chocolate scented soaps, that would probably be a problem for Dove chocolate. They'd be like, you can't do that. They'd probably end up sending cease and desist because it would get a little dicey.
I never thought about that. Considering that they both have the same name.
Mm-hmm. They're both sold in grocery stores, which is because you have to look at the channels of commerce that they travel in, right? But at the end of the day, no one's going to pick up a bar of soap, bite into it, and think it's chocolate. So we're not too worried about consumers getting confused.
What's the recent commercials when you get the food? It's Uber delivery.
Oh, Uber Eats, yeah.
And so
or GoPuff.
Now they're delivering stuff, and all the celebrities are eating soap and other miscellaneous items.
Oh my God.
I love a good marketing show. I do. Yeah. I love good marketing.
Marketing's great.
It's bizarre commercials, but totally.
Well, you remember it.
I do.
Yeah.
Totally bizarre. Excuse me. Okay. So then how does a small business owner in particular know when to file, and how what is the easy formula to know between a service mark, a registered trademark, a copyright? Like, how do you know when you need to be in
Doing
what
what?
category?
Right. So the easiest way to break it down is copyrights are for creative. So creative stuff you make, drawings, pictures, music, artwork, photographs, anything like that. So copyright's creative. You can think of it that way. Trademarks are for brands, brand protection. So it could be your trademark. It could be your service mark. It
Like
could be,
WorkHARDAholic.
yeah, exactly.
Okay.
It could be, in some cases, it could also be packaging. That's a little bit more complicated. But for example, Maker's Mark has the whiskey has that wax red dip that
that drip down
the drip down it. Yeah, that's a trademark. That's a registered trademark. And Tiffany, the blue
Oh.
boxes, those are registered trademarks. So Louboutins, the bottoms in America, they're still a registered trademark. In Europe, not so much, but that's a story for another day. So those are all registered trademarks and like the packaging and presentation. That gets a little complicated. But then inventions are for patents. So that's your biomechanics, your computer stuff, all that. And, I send those out to a wonderful other lawyer, Dawn Marie Bay. She's in Richmond and she does all that. And it's really cool stuff. It's fun.
So then I heard you mention, we are unfortunate about the wrap up. That sounds crazy, but it's true. So I will make sure I get everything in before, as much as I can.
Yeah.
We can always have you back though.
I will do whatever. I love it.
Good answer. So if I'm a small business owner
Mm-hmm.
and I'm going, okay, so like we're workaholics, and I'm like,
Right.
I made that word up. I did, in case you were all wondering. I made that up. So want to trademark it. I'm not sure what I want to do. I just know I have something unique and I don't want someone else using it.
Right.
So what's the way to proceed? Because everyone, like, I know for me, whenever I'm talking to someone, they're mentioning things and I'm sitting in a consulting session, I'm immediately going to the SEC to see, does this company name exist? And then I'm going over to USPTO website and I'm looking, but most people don't know
Yeah.
what to do. So how do they know what to do, and when do they know when they need you?
Yeah, and it's interesting too because the USPTO website in particular looks like it's straight out of 1995, and it is not easy to use, and
It's very clunky.
it is more like a calculator than like a search engine. So you have to remember it's not like Google. It's not going to pull back results that are similar, like the results you actually need for the USPTO or for a trademark search. So I actually pay a third-party service that indexes the entire USPTO and works more like Google. So it pulls back the results you need. So the reports that I get from them are like 800 pages long, but it gives me a better idea of what's going on. So it's very much a chicken or the egg. If you have the finance, the issue is finances. And it's always going to be the issue with entrepreneurs. It's always going to be, what are we funding first, and what are we making a priority for the finances we have? And trademark applications, lawyers, the attorney's fees, period, are expensive. The application fees are $250 a class, and you always are going to at least have one application fee. Usually the applications I file, we're doing two classes. We usually can like get away with two. So in a best case scenario, you would be filing before you launched. If you are a service-based business, you have a little bit more wiggle room because a rebrand isn't as, it's devastating. Obviously, a rebrand would be if you launched, somebody was like, oh, cease and desist, you don't get to use this. But if you're a product-based business, it is so much more important to get all your clearances, do the intent to use 1B application before you go to print or you go to production, because I've literally had clients where we have had to go into stores and pull product off shelves. Yeah. So that's the hard part. And then you either have to destroy that or repackage it somehow, but it's an expense. It's a huge expense on top of having to rebrand and on top of like all this other stuff. So I would say if you have a product, do it before you launch. And file it before you launch. If you have a service, you really, really should clear it and get it filed before you launch the company, launch the service. If you have a signature product that you are going to be, or a signature service too, that you have named something special, we're going to want to really look into, okay, is this something that we can trademark as well? Because if it starts to become, like you said, the Xerox or the Velcro where everybody uses it for everything, Koozie, Koozie and Velcro are fighting very hard to keep theirs from being generic. So if they are new in their field, I've had this happen to one client, they're new in their field and they like are really starting things, that might become the default name for something. So then we have to make a strategy. Okay, how do we do this? How do we redirect? So the best case scenario is do it before you launch and have a plan. The practical implication of all that, with knowing that our finances are always limited and we're trying to figure out where to put them, is
Indeed.
do it as soon as you can, because the sooner you do it, the less problems you're going to have and the less potential issues you'll have down the road. Because maybe you launch your company and somebody's like, oh, I also had that name that I wanted for my company. And then they file the application. Well, they've just poured sand in that mason jar all over everywhere else. So you can't expand. You get boxed in. And that's the hard part of figuring it all out.
And so I know pricing is always an interesting thing.
Yeah.
But generally speaking, for I'm going to say simple.
Yeah.
So new business, getting started, doing the average 2 categories.
Mm-hmm.
What are the general fees working with you?
So every lawyer is going to be different. My practice, we work on flat fees because we have done I've done this so many times. I know how long it's going to take. So our all in for one class of goods and services, including one class of goods and services, is $2,250 right now. So $2,250. If you add another class of goods and services, it's $2,500. Now that is a 9-month, 9 to 12 to however long it takes at this point process. So you've got a lot of it. If you think about it, it's very reasonable because of the timeline. Usually you file and then it's 3 months, 4 months before you hear anything. Right now it's actually running 6 months at the USPTO before they even open your file.
I believe
it's awful. It's terrible. They're just a mess over there right now. But so it's about 6 months. So we'll check in every month and say like, hey, nothing's moving, nothing's changing. We're still looking. And then after that, you'll have either pushback from the USPTO, which is an office action. So it's like a preliminary refusal, or it'll just kind of sail right through, which would be nice. But I think it's like 70 or 75% of applications get office actions. So that's all included. We do all that. We answer it all. We do the arguments. And I would just encourage anybody that is talking to trademark lawyers to ask whether those office action responses are included, because that's where it gets expensive. That's the expensive part that a lot of people don't think about. So, I mean, office actions can take anywhere from like 30 minutes, me just fixing a couple things and be like, all right, cool, that's fine. Yeah, we agree. Or it could be, I worked on one for 12 hours a couple weeks ago. So it evens out for us because I kind of know how long it takes. But if you're walking into something where there's a potential for pushback, it could be a really long time. You could have a lot of stuff. And if they're working on an hourly rate,
but to me,
that's a lot.
That's the reason that we get experts.
Yeah.
Because that's like, it might take you 12 hours, but I mean, if I'm working on it, I'm 3 months in.
Yeah.
Trying to figure this out. Okay. I know. It's time for us to go. We want to say thank you to Caroline for being with us today. But tell everyone how they can reach you, how they can contact you, social media handles, and we'll be sure to post it on our website as well.
Awesome.
And our social media so that you can find her, because we want you to make sure that everything you do is protected, because it's a lot of work for it to be lost for a technical reason.
A brand is a beautiful thing. It's too beautiful of a thing to waste.
A brand is too beautiful of a thing to waste.
See, I have one-liners too. Okay, so if you're looking for me on the internet, cjfoxlaw.com is my website. That's the easiest way to get in touch with us, honestly, because our phone doesn't stop ringing because my phone numbers are all over the internet and bots are real. So cjfoxlaw.com. I'm on Instagram at cjfoxlaw, and I'm actually on TikTok at something different. So it's just a lawyer and her dog on TikTok. We love TikTok. There's a lot of lawyers that I've connected with there. Fun.
We need a new Schoolhouse Rock video.
Oh my God.
Come up with something with patents and trademarks.
That would be great.
Because then they'll be like I am. How many years later? I'm just a bill. I'm trying to tell you, it's still in there.
Yeah,
it's in there.
I'll
be looking for that for one of your TikTok videos, and I'm going to know the idea came here. You will know.
We'll give you credit.
We will take it. So once again, thank you so much.
Thank you
to our amazing friend Sarah McCurry for introducing us.
Love Sarah.
To the amazing Caroline King. And thank you all for joining us on WorkHARDaholics. As we always say, live better, do better, be better, and happy entrepreneuring. See you next Sunday. Like, share, subscribe, repeat. Like, share, subscribe, repeat. Like, share, subscribe, repeat. Repeat. Repeat.